My name is Richard Uslan. I'm an attorney in Somerville, New Jersey, and I've been practicing criminal defense and municipal court defense for over 30 years. You're watching this video because you were arrested in Parsippany, Troy Hills, for a drug-related matter. And in this YouTube video, I'm going to explain what an experienced defense attorney is going to do to try to help you with this. The first approach is going to be to challenge the seizure and subsequently the search that led to the drugs being recovered, whether it was from an article of clothing you were wearing or from the car that you were driving while you were in Parsippany, Troy Hills. The police generally have to have a constitutional reason to conduct a reasonable search and seizure. That begins with the seizure. Generally, it is preferred to have a warrant, but there are warrantless exceptions. I've combed over the search and seizure case law for 30 years so that we can challenge this by way of a motion to suppress evidence, where I cross-examine the police officer who claims that there was probable cause, first to stop you, and secondly to conduct a search of you. One of the more common tactics the police are using now is to circumvent a case called State versus Peña-Flores, where they would ordinarily have to demonstrate, in addition to a reasonable belief that there were drugs in the vehicle, that there were exigent circumstances to conduct a warrantless search. So they tried to use a consent form to obtain your consent for the search. The consent really isn't consent, as you may know from your own experience in Parsippany, Troy Hills. You may have been told about having to wait several hours excuse me, as an alternative while the police try to get a telephonic warrant, or that the police are going to threaten to bring the canine dog unit over to sniff out the drugs from the vehicle that they suspect has the drugs in it. So an experienced attorney is going to challenge the validity of this consent because it was under duress. Additionally, another way to challenge the admissibility of drugs is by challenging the chain of custody of the evidence obtained. By that I mean, once that evidence is recovered from the police, it has to be brought to the police evidence locker. Then it's transported from there to the state police laboratory for analysis. Then the remaining drugs are brought back to the police locker. And then on the trial date, those same drugs are the ones that have to be produced at time of trial. Any break in the link of that chain is going to result in those drugs not being admitted into evidence against you, and you're going to be found not guilty of possession. I've combed over the evidence chain of possession in thousands of cases. An experienced defense attorney can help you, so don't give up hope. I look forward to speaking to you and answering any more questions that you have in this matter. I've been prosecuting as an assistant Essex County prosecutor over 30 years ago. I was a prosecutor as a municipal prosecutor in the municipal court, so I know what has to be proved against you, and I know how to defend the claim against you.